Good morning, everybody. Welcome to the First District Court of Appeals this morning. We have 3 cases on our docket that will be argued. The first 2 cases, excuse me, I'm not having luck with my chair this morning. The first 2 cases that will be argued will be in front of this panel. We'll then take a brief recess, and the third case will be argued in front of a panel consisting of Judges Zayas, Winkler, and Bach. So our first case on the docket this morning is In Re MK. Ms. Moss, you will have 15 minutes to argue this morning. Would you like to reserve any of that time in rebuttal?
Yes, Your Honor, 3 minutes.
All right, and I will keep your time. Whenever you're ready, you may begin.
May it please the Court, Jessica Moss on behalf of the appellant MK. This case is about 3 separate challenges to the imposition of Department of Youth Services commitment under 4 case numbers. As to the first assignment of error, the juvenile court erred in denying MK confinement credit for time spent at Hillcrest under case number 19-4797. Now, Revised Code 2152.18b requires that the juvenile court reduce the minimum period of commitment by the number of days confined.
Right, and I guess can you help me with this, because what the state says is he did get credit for that, and what you're saying is, well, that's how it works in adult court, or adult prison, but not with respect to juvenile court. But I was having trouble following why is there the distinction there, and what is the authority that supports that?
So the authority is under the specific statute of 2152.18, talks about each specific complaint, and that's what makes it different than the adult statutes. The wording is different, and the nature of juvenile cases. Juveniles are different, and we understand that the purpose of juvenile court, one of the purposes is rehabilitation, and we know that juveniles are not the same as adults. And so when we look at reducing the minimum commitment each time period, so for each particular case, and in this case, he was at Hillcrest, and we know that that was confinement credit because he was given credit on the other case. But he was also at Hillcrest under this 19-4797 case. And the cases that the state cites to have never been applied to juvenile cases and have never been applied to the 2152.18b.
But you don't have any authority that says, you don't have authority in the juvenile context saying this is how it works, right? Because what the state is saying is you're effectively triple or quadruple counting the credit if we do what you're suggesting.
So the only authority is under the statute.
Right.
And because the juvenile court only controls the minimum period of commitment, and that's why in the other assignment of error as well, the minimum commitment's important to know what that is, and knowing then how many days to reduce that commitment. So MK could potentially spend up until age 21 at Department of Youth Services. After that minimum period of commitment, it would be up to DYS to determine whether or not how long he should continue. And so giving credit to all, again, is different than in adult cases because you have that control by DYS after the minimum period of commitment. Excuse me. As to the second assignment of error, the juvenile court violated MK's right to due process when it imposed a suspended commitment to DYS in case numbers 17-6652 and 15-4663. So there's 2 issues here. The first is the lack of jurisdiction to revoke probation when the court does not comply with Juvenile Rule 35. And the second issue is failing to follow the requirements of Juvenile Rule 29. And these go hand in hand with one another.
And can you help me? What is the failure to comply with 35? Because are you saying that the court could never essentially sua sponte raise these issues?
Correct. So we know from LAB that probation revocation hearings are adjudicatory hearings, and you have to follow Juvenile Rule 29 and Juvenile Rule 35. Now, you could potentially have a probation violation without trying to impose a suspended commitment, but you can't have imposing the suspended commitment without a probation violation also being filed. And so those collectively both need to happen to then impose a suspended commitment. And the whole point is that the probation violation is what notifies the child of the alleged violation that had occurred and gives the child their right to this adjudicatory hearing to determine whether or not that in fact did occur.
Well, but so in this case, the magistrate says on whatever the date was, April 7th, hey, this could implicate all four of the charges against you. And so the magistrate gives the juvenile court, or the juvenile notice of that. And then there is the filing by the state on April 11th to invoke the continuing jurisdiction. And then there's the hearing on April 12th. So from a due process standpoint, I have a hard time seeing how the juvenile did not have adequate notice that this eventuality might come to pass.
So on the April 7th date, the only case before the court was the 2614 case number. And even though the court said it was going to impose this and send it to the judge for determination, that doesn't mean that the juvenile actually had notice of the violation. And in fact, the two case numbers, as to the second assignment of error, this juvenile was only on monitor time, which means the only way that his suspended commitment could be invoked is if he violated the law. And the two separate probation violations that were filed on the other two case numbers talked about not completing Hillcrest, as well as being violating the rules of probation.
But is alcohol consumption by a minor, would that be a violation of the law?
Potentially it could be, but not necessarily in this case. The allegation was that this occurred in his home, and it wasn't charged as a violation of law. It was only charged as a violation of probation. So having a probation violation, the whole purpose of this due process is that it would give the juvenile the right to have a hearing to determine whether or not that was actually, in fact, a violation of the law. That didn't occur here. In this motion for suspended commitment means nothing without this probation violation also being filed. Additionally, this goes hand in hand with the In re AS case that this court held. In that case, there was a receiving stolen property charge as well as a burglary charge, and only a probation violation was filed on one charge. And this court determined that you cannot invoke the suspended commitment on a charge where there wasn't a probation violation filed, and that's exactly what this court, the juvenile court, did. The juvenile court essentially bypassed this whole filing a motion for a probation violation altogether to impose the suspended commitment on these two case numbers. Excuse me.
And to make sure I understand, you're drawing a distinction between the filing of the probation violation and what the state filed on April 11th, which was a motion to invoke continuing jurisdiction. What is the substantive distinction between those two?
So Juvenile Rule 35A talks about the motion to invoke the continuous jurisdiction. And Juvenile Rule B talks about the probation violation, and that's where the two go hand in hand. And there have been a number of cases that talk about due process is only satisfied if you comply with Juvenile Rule 35, and that would entail both of those cases. Because again, you can't impose a suspended commitment unless you know that there's a probation violation. The juvenile has a right to have a hearing to determine whether there's been something that has been violated.
So you said 35B, but where does that say probation violation, like motion?
It's a motion to revoke community control or probation. So that's the whole point of imposing, if the court is trying to impose the suspended commitment, there has to be this motion to revoke probation being filed, because you can't revoke community control probation if you're being sent to DYS. It's either one or the other. And as to the third assignment of error, the juvenile court abused its discretion in ordering MK to serve the minimum commitment of 3 years under the 22614 case number. Now, at the time of the initial disposition, MK was not notified that it could be a minimum commitment of 1 to 3 years. He was only told that it was going to be up until his 21st birthday. And again, that was reflected in the dispositional entry by the court.
I thought he was told there was a minimum of 1 year. Am I misremembering that?
On the April 7th date is when he was told it would be a minimum of 1 year. So at the initial time of the disposition, not told it would be 1 to 3 years. And then at the time...
Is that like Giles in the adult court? He has to be told specifically what the consequences are going to be?
Yes. And then at the time of this sua sponte imposing or trying to impose this suspended commitment, that's when he was told it was 1 year. And again, that's what's important, because the juvenile court only has control over the minimum periods of commitment, and knowing how much to reduce the time that he has been, was at Hillcrest. And here, he spent a significant amount of time at Hillcrest, and that would be important to know for DYS. Has he met that minimum period of commitment or not? Additionally, ordering this 3 years was arbitrary and unreasonable because just the month before the probation violation was filed in this case, the plan was to release him from Hillcrest. And the court, even in December of 2021, recognized that he had changed for the better and was making progress. He had completed a number of programs at Hillcrest, including Thinking for a Change, aggression replacement training, substance abuse treatment, and it achieved RAM status, which was one of the highest levels at Hillcrest, which allowed him to have home passes. He had also
We have about
graduated
2 minutes left.
graduated from high school. I'll reserve the remainder of my time if there's no other questions.
All right, well, you'll have 4 minutes then.
That's
So
fine.
you'll have 4 minutes on rebuttal.
Thank you.
Mr. Havlin? Will you start with the issue that, the argument that he wasn't properly notified at the time of his disposition?
Sure, Judge. So, and I think the question's kind of honed in on, I think the issue in this case is really the lack of a PV in those two cases. There were probation violations, sorry, I don't mean to, for the record, if this goes anywhere. There are 2 probation violations filed on the newer cases. It's the 15 and the 17 case, no probation violation. Judge Bergeron, I think I heard this question right. I was also looking something else up. And it's the state's position in this that there's nothing in Rule 35 or 29 says probation violation or a motion for it or anything like that.
Right, that's what I was trying to figure out.
Right, so it's not required by the rules. I think, and this is my first experience with one of these, and my experience as a juvenile court prosecutor, pre-AS, as you're all aware, we used to just say like, oh, and these 3, and then they'd add the time. Now AS, we have to have some notice. I think this is a good example of that notice being given, and that's what I write in my brief. The April 7th hearing, the magistrate says explicitly the juvenile is present and represented by counsel, that I am putting these in front of the judge. The cases that we're here on today, and also these suspended commitments that you have, for the judge to consider whether or not to impose those commitments along with these newer ones for which you've violated probation, like reporting probation. The other kind of weird thing on this is on these 2, he's on the non-reporting probation.
Well, and so, like, the argument that Ms. Moss was articulating about, like, well, there was no violation of law potentially here, and the question of, like, whether alcohol consumption satisfies that. I mean, was that argument made below at the trial court in terms of saying, like, hey, Judge, you can't impose the suspended commitment here because that wasn't actually a violation of law? I
don't believe so, and I'd take minor issue with that characterization, and I apologize, I don't have the transcript of the docket numbers in this. On the entry suspending the commitment, it says basically will be suspended, and the language is, commitment is suspended on the condition that defendant obey all laws and orders of this court. So there's a second part of it. And I don't think there's he admitted to probation violations on the other two charges. So I don't, aside from the minor, the minor consuming alcohol issue, there's an admission to a violation of an order of the court in these cases. It really just, it comes down to whether that had to be, and I have this in my notes from before I wrote the brief, I guess the proposed solution to this is that the juvenile probation officers file a probation complaint on monitored time cases that say you violated a law or order of the court. I guess that's the position. I don't see that as required by either of the 2 applicable rules, 29 or 35. And I think, if we look at AS, if this were that situation, sure. If it showed up, it had never been mentioned, and at the day of initial disposition.
Right. I mean, that's the distinction.
Here's the extra
That's
time.
the distinction with AS. Like,
Sure.
the juvenile there was not notified at all.
Right.
Of the possibility of that.
Right.
situation.
And sorry, I didn't want to interrupt, but going back to another point you made, the Rule 35 just says a motion. I believe that the magistrate can, on its own motion, invoke the continuing jurisdiction of the court. Courts generally determine their own jurisdiction, and it's not like this is a reach for a case. This is a case this court obviously had. It had other cases before it that there's no question about its jurisdiction. I think it's appropriate. All it says is shall be invoked by motion filed. Even if the court's, their initial motion, the magistrate's own motion didn't work, the state did file those motions 4 days later, listing all of these. The probation violations filed in the two newer cases list specifically suspended commitments in these two old cases as well. So I think I don't think either of the rules require that violation. And this record in this case, I think demonstrably shows that notice was complied with. I'll briefly touch on the first assignment of error. Judge Bergeron, I think this was your question also. I'm unaware of any reason or certainly authority, case law or statutory or otherwise, as to why Fugate wouldn't apply in the juvenile setting. I don't want to get too far in the weeds, but jail time credit it's an equal protection. Its genesis was equal protection. I'm not sure of a more equal protection for juveniles thing. It's just the math. And it's the nature of the sentences or commitments, in this case, whether they're consecutive or concurrent. That's the distinction there. And if
The appellant relies on statutory interpretation on her first assignment of error.
Sure.
How would you address that?
The B section. I don't think that statute, that section basically just says juveniles are entitled to credit. I don't think it adds anything to the calculus. It mirrors in large part the adult section that says adults are entitled to credit. I don't see anything in that section that would upset the well-settled calculation of credit and the way that it applies in a consecutive vis-a-vis concurrent sentencing decision by a court. If there are no other questions on that issue. And then assignment of error 3, I think, Judge Bergeron, you asked this question also. I believe that, let me back up for a second. I'm unaware of any case, the two cases cited that require at the time of initial disposition or sentencing, the specific term be laid out for a hypothetical failure of community control. Those come from the adult realm. I'm unaware of any juvenile statute that requires the same. And at the time prior to the admission, the magistrate or judge, was it the magistrate or the judge? So forgive me, said 1 year to 21. I think that's within the range. And then the case I cite from the 6th district, I believe it is, basically says we presume that to be reasonable.
So Giles has never been applied in the juvenile setting.
Not that I know. And then I forget the two cases that are cited in the appellant's brief, same deal. It's citing the specific statutes applicable only in adult criminal proceedings that require that sort of specificity at the initial sentencing there or disposition here. If there are no additional questions, I just ask that this be affirmed.
Thank you. Ms. Mosh, you have 4 minutes remaining.
So as to the issue of this monitor time, even if the court put in their entry of whether or not it's violating the law as well as violating a court order, the juvenile still has a right to have a hearing and notice of that type of violation on the particular charge. And when MK went to court on April 7th for the 20 case number, he was only there for that case. He had no knowledge that there was any other cases that were going to be before the court.
But if the reason for notice is to be able to defend against it, wasn't he able to here? He was represented by counsel. He had maybe not perfect notice, but certainly notice of it. What would or could he have done differently under your scenario?
Well, first of all, a motion for probation violation should have been filed in these other two cases if the court was going to consider doing something with this probation violation. And while his attorney did argue as to these issues, there wasn't a chance for a full hearing as to a potential violation under that specific case number.
What, did counsel ask for one? A full hearing?
Counsel did not. And so there was an admission on the 20 case number to that violation because
Well,
that
I
was
think
the only
that-
probation.
That's kind of the thing that I'm struggling with too, is like you're saying there needs to be a full hearing, but he's admitting to these charges. So, like, what would I don't understand what the hearing would look like if he's not contesting them.
So at the time of the April 7th hearing, there was only one probation violation, and that was for not complying with the terms of Hillcrest. And so the other two, the older two case numbers, where MK was on monitored time, there was no order to comply with Hillcrest. And so there would need to be some hearing on that as to those two case numbers, and he wasn't afforded that. He was only aware that there was going to be a probation violation filed on the 2020 case number. And even if a juvenile court on its own could invoke the continuous jurisdiction of the court, that should only be after a motion for probation violation is filed. So let's say the state files a motion for probation violation or probation files that, and the court looks at it and says, okay, now I want to invoke the continuous jurisdiction and puts on an entry to that effect. There's still that motion for probation violation, the right to have an adjudicatory hearing on this issue. And that's where due process comes into play on these two case numbers, where MK was not afforded those due process rights, and the juvenile court therefore did not have jurisdiction to impose the suspended commitment on those two case numbers. As to the third assignment of error, because the court did not give him this 1 year to 3 year and only said, even on the April 7th hearing, it's only going to be 1 year to 21, it should only be the 1 year minimum commitment that is imposed for the 2020 case number.
You have about 1 minute left.
For these reasons, we are asking that you reverse the juvenile court's decision. You grant MK an additional 528 days of credit for the time he was confined at Hillcrest under the 194797 case number. Vacate the commitments under the 176652 and 154663 case number, and determine that he is only subject to the minimum of a 1 year commitment under the 202614 case number. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the case under submission, give you a timely written opinion. I'll give you all a minute to vacate the tables. The next case on our docket this morning for argument is State versus Nicholson. Ms. Nelson is here on behalf of appellant. Mr. Otero is here on behalf of appellee. Ms. Nelson, you will have 15 minutes to argue this morning. Would you like to reserve any of that time for rebuttal?
5 minutes, please.
All right, I will keep your time whenever you're ready.
Okay. Good morning, Your Honors, and may it please the court. Good morning, opposing counsel. Sarah Nelson here on behalf of the appellant, Mr. Joshua Nicholson. This morning, I intend to focus on the first assignment of error, the statutory speedy trial issue. Unless the court has any questions, I'll submit on the sufficiency and weight, and also on the restitution, in light of the fact that the state has conceded the third assignment of error.
And if you could keep your voice up just a little bit.
Okay, no problem.
Thank you.
So with respect to the first assignment of error, the statutory speedy trial issue, there are three things I want to talk about this morning. The supervised OR bond question, the State versus Blackburn case, and then what was actually charged in the felony cases. The supervised OR bond was imposed at the January 17th hearing. This is all in respect to the 22 CRB 785 case. But that OR bond, supervised OR bond, doesn't stay, in my opinion. I think the record reflects that on the January 21st hearing, counsel asked the court to impose a nominal bond on all the cases, and the court agrees to do that. I think that's reflected at page 20 of the transcripts. The court agreed to impose a nominal bond. So there's no longer an OR bond on the 785 case, which means he's back to getting a triple count. And this is important because of the time in between January 25th and January 31st. It's pretty much conceded, I think, that from the date of the arrest of December 22nd, 2021, until he's arrested on the 785 case on January 16th, that triple count provision applies during that time period. Then there's some question about the OR bond and what happens after that. Even if we give him an OR bond between 117 and 125, there is some tolling in there as well. Even if we just take out that entire piece of the puzzle, the triple count would resume at 125 when the state's continuance kicks back in after the state responds to the defendant's discovery request. I'm going to pause in case there's any questions, because I know this is kind
I'm
of
looking
confusing.
at my chart here. on
Yeah.
all this to
Okay.
Make sure I'm following you.
Okay. So I just wanted to address the bond aspect of it, because I do think triple count does kick back in between 125 and 131, which gives us an additional 18 days plus the initial 75. I think in that narrow time frame, without the additional tolling continuance stuff in the middle, we have at least 98 days beyond the statutory allowed amount of time. The second point I wanted to talk about is the State versus Blackburn case, which suggests that maybe there's no difference between continuances and it's a continuance versus an expressed waiver question, I think, is what we have here, following the January 3rd event, where defense counsel on the 21 CRB case asks for a continuance, waiting to see what happens with the pending felonies. I think the error in this case by the trial court is applying the waiver of time from 1-3 to 116 back to the 785 case that was filed on 116. So we have two separate cases, as this court is well aware, the 21 case and the 22 case. I don't think the 22 case the waiver in the 21 case should apply to the 22 case, and that's the crux of my argument. And I don't think that the principle announced in Blackburn, where it was a continuance or was it an expressed waiver, is appropriate here.
Well, let me think about that a little bit. I want you to maybe explain that further.
Sure.
If he's asking for a continuance in one case
Yes.
and not the other, that's your argument?
Correct.
That he didn't want the other case continued?
Well, the other case is hypothetical at this point. We don't actually know if it's going to be a case because it's pending indictment. And I think what's important about Adams, Blackburn, and Homan is that, or specifically Adams and Homan, is that when defense counsel is making a decision, it's tactical in the sense that they need to wait to know all the charges before them before they can start making actual strategic decisions about a case. And I think that's what was going on the 1-3 day. Counsel was continuing, waiting to see exactly everything that was on the plate.
So in that case, you agree it was waived?
Yes, and I think the
Okay.
trial court expressly construed that event as a waiver of time. So I think the record reflects that it's a waiver. The actions of counsel demonstrate that it was a waiver. I don't think this court should follow Blackburn in the sense that it's construing it as a continuance that wouldn't apply.
Okay, I misunderstood your argument.
Sorry, it's a little
Thank you.
confusing, and we have three different cases that kind of talk about different principles, but I think it's very clear in this situation that we do have a waiver. That waiver should not apply to the 2022 case, 22 CRB 785. And if there's any confusion, I just wanted to talk about what was actually charged in the felony indictments, which I believe is clear that the Ford F-150, which is the subject of the 22 CRB 785 case, was in fact the facts charged in the felony indictment. So these are absolutely facts known to the state back in December 2021. And therefore, it's not new information, not known to the state at the time of the arrest. So therefore, the state doesn't get the benefit of a new speedy trial clock. It all relates back to that date of arrest on December 22nd, 2021. So for those reasons and for the reasons outlined in my briefs, we would ask that the court dismiss the 22 CRB 785 case for lack of speedy trial, for the speedy trial violation. if there's no questions, I'll just reserve the remainder and respond in rebuttal.
All right, and you will have 8 minutes in rebuttal.
Okay, thank you.
Mr. Otero?
Good morning, Your Honors. May it please the Court. Joe Otero on behalf of the City of Cincinnati. Your Honor, I do plan on addressing counsel's arguments, but to begin the first portion of my argument, I'd like to focus on why I think that why the case of 785 was not held to the same speedy trial limitations of on case 22 CRB 785, not held to the same speedy trial limitations as case 21 CRB 22360A. It is the state's position that under the case law of the Supreme Court cases of State v. Adams and State v. Baker, that the two cases in question here share facts that are separate and distinct, and therefore the subsequently charged case under 22 CRB 785 should not be held to the same speedy trial limitations. As I'm sure this Court is well familiar with, in State v. Adams, the Supreme Court established that where new and additional charges arise from the same set of facts as those found in the original charge, and the state knew about those facts at the time of the initial indictment, the time frame within which the new charge is to be tried is subject to the same speedy trial limitation as the original charge. However, in the context of the Adams case, we're dealing with a different type of scenario here. In Adams, it was the defendant was charged with an OVI under one statute of the OVI provision. Later, a period of time elapsed, I think it was several months. They dismissed that original charge and charged him under a separate OVI statute. But within that case, you see it is only the one act. It is the one OVI instance. And that's what's different here, is that these two cases they're both charges of criminal damaging, but different victims, different cars, different locations, different times. So to the Adams case, set forth this precedent and this progeny from the cases that derive from it, really with the understanding that it was the exact same act when dealing with the original indictment and the subsequent charges. But for purposes of the cases that we have here, this may have happened under the same course of time period. I think within the record, we know that there were 57 tires that were slashed that night as part of the officer's investigation, but those are 57 different cases at this point. It's not like the same OVI case or charge or act, I should say.
So if the statute of limitations hasn't run and they discovered another victim of this series of events, you would argue that they can still bring it. It's a separate crime.
Yes, that would be my argument, Judge Myers. Later, the Supreme Court of Ohio would clarify this in State v. Baker, in which it would hold that when the facts of the case are separate and distinct, which we argue that's the situation that we're in here now, is that it is not that the subsequently indicted case is not subject to the same speedy trial limitations at that point. I think when you look through the Baker case, it's more similar to our case, where the defendant Baker was originally charged with drug trafficking. He was later found, upon further investigation, he was later found to have committed some auditing crimes and further drug trafficking cases. While it's under the same umbrella of the original investigation, the Baker court and other courts have found that even if it's a part of the same investigation, it's still separate crimes. That's what we're asking you to consider here at this point. And additionally, as to the Baker charge, it says where there are facts unknown to the court or unknown to the state or different facts, we would ask that that is a disjunctive holding at that point, the key word being or. It's possible, I've looked through the record on this, I know that in the second case, the 22 case, that the victim reported finding out that her tire was slashed on December 20th, but I don't think that we know in the record at what point the state became aware of that, what time she reported it to the police. I could be wrong about that, but I tried to read through the record again. I don't think it's ever clarified. So it's possible that this was known back on the time that it was, December 20th through the 22nd. However, the key word in the Baker holding is the or. State believes that makes it disjunctive. So all that matters at that point, we would argue, is just that it's different facts, which is what I've been honing in on here. So, and the reason that I advocate for the disjunctive holding in Baker is because where do you draw the line at which point the state actually knew of it? There were 57 different tires that were slashed that night. We don't know when the police were able to find out who the owners of those vehicles are. We don't know at which point the state was comfortable bringing charges at this point. I don't have a good reason for the delay from December 20th up to January 16th, but I think that if you're going to require the state to bring charges as soon as it's aware of one crime, you're possibly putting pressure on the state to preemptively file charges when it's not prepared.
Well,
So-
but I guess my question about that in the context of this case is it's not like you needed to investigate like whether a crime occurred. I mean, you had like these 50 tires that were slashed, and as soon as you had reason to charge someone for at least one of those and had reason to believe that he was the perpetrator for all of them, like what is the justification in waiting at that point?
Judge, I think that's a fair point to be made. We don't know if this person was acting alone at this point. 57, vehicle slashings in one night is a lot for one person. So I think just for caution at that point, not to jump too quickly at the opportunity just to initiate a charge on somebody at that point. But that is certainly a consideration that the state would have to go forward with, where it's, do we go forward on this just because we're confident that he slash some of these tires, but to go forward on all 57 charges at that point, I do think it would take a bit more investigation at that time. If there's no further questions as to the Baker and Adams case, I'll move on to my second portion of the argument. As to the second portion of my argument, this is focusing on the Adams and Blackburn case that opposing counsel touched on. And Judge, yes, this is, I think, the crux of this portion of it. If you were to find that these cases are not different for the purposes of Adams and Baker, if you do think that this was a part of, the same facts, we would just ask that you consider how do we come down on this idea of waiver versus tolling. I believe it's in State v. Adams again, where they said that the concepts of waiver and tolling are different, and that on a subsequently charged case, a defendant is not able, or the court should not pass that time waiver onto the subsequently charged case because the defendant can't voluntarily and intelligently waive that right for a charge that they may not know has been filed yet. But where we find ourselves in this case is that there is a time tolling provision, that motion for the continuance on January 3rd that eventually went up to January 18th. That was something that was completely out of the state's control at that point. As opposing counsel said, they were waiting to see what was going on with the felony at that point. It was a common pleas jurisdiction. There was nothing the state could have done to expedite the process to figure out what was going on with the felony. So in terms of this being a time waiver, I would say look at a case like Cheatham, where you look at the underlying source of the continuance, the reason for the continuance at that point, and it's the defendants. The state was in no position to prolong this case from January 3rd up to January 18th. So because of that, I think we're going to have to figure out how does waiver versus time tolling, when they butt heads like that, how do we figure out who the time actually goes against in that time period? I would argue because the state really had nothing that they could do during that period as a result of waiting on defense to figure out what's going on with the felony, I don't think that time should be charged against the state. And when you cut out that January 3rd to the January 18th, or even the 16th, that is when the 785 case was actually charged. You could either do January 3rd to the 16th or the 18th. That amount of time that you take out, if you don't count it against the state, there's really any way you cut the time at that point, the Nicholson should have been brought to court within the allotted speedy trial time. And if there are no further questions, I would submit on my brief at this point.
Thank you.
Thank you.
Ms. Nelson, you have 8 minutes remaining, and I want to start by just simplifying one of your arguments, if I could, and tell me if I'm wrong about my understanding of your argument. One of your arguments is that this was one event, 50 different tires slashed, one event, and therefore the two cases, we consider it as one event, not two.
Correct.
All right. Now, here's where I want to make sure I understand. What if it was someone going on a joyride and running into mailboxes, and they ran into some in Price Hill, and then they took off and they went up to Coleraine, and they ran into some in Coleraine, knocked those down, came on the loop of 275, did some in Forest Park, came all around. You see where I'm going. Is that one event under Baker? Is it, I mean, it's sort of the same. These tires happen, these cars